This is preposterous. This is nonsense. That he observed me driving. That's a lie. Falsus in unum, falsus in omnibus. False in one thing, false in all. I'm not contracting with this. My constitutional rights are broken.
All right, court next calls the people of the state of Michigan versus Philip Andrew Leffers.
And yes.
This is all right. This is case number 26819FY. We are here for a probable cause conference. We're also here. Mr. Champion has filed documents on behalf of Mr. Leffers. One of those is an affidavit of non-acceptance of court-appointed counsel, assertion of constitutional rights, and demand for self-representation. The other is an affidavit of notice and acknowledgement and acceptance of oath of public official. The other is a respondent's motion to set aside a default judgment. Before we begin today, I'm going to remind everybody of the court rules and local administrative orders regarding the court decorum and procedure. I'm going to ask if anybody is recording these proceedings that they please shut off their phones. I'm also going to ask that any phone be placed in a pocket or purse in such a way as it cannot be seen from the courtroom. If you could stick that in your side pocket, sir, I'd appreciate it. Appearances, counsel.
Lisa Doe for the people.
Robert Hertel for the Defender's Office. Your Honor, Mr. Champion was in Misaki this morning. I'm sure the court also took note that what we, from the Defender's Office filed, we included a qualifier of it not necessarily being endorsed by the Public Defender's Office. I wanted to make sure to stress that.
Correct, I understand that. So, Mr. Leffers, I know, I think you've been in front of me twice, and I think you were in front of Judge Ransom last time. I know your position regarding the authority of the court. To keep matters moving, though, I have to set a time limit as to how long I'm going to allow you to address the court. Hold that thought. I know you always have a concern, and rightly so, as to whether or not we're on the record. My concern is from where you're standing, I'm not sure the microphones are able to pick you up well enough to get an accurate record, and the court reporter is telling me that. So what I'm willing to do for purposes of this case is I'm going to put on notice that allowing you to pass behind the bar and enter into the well, I'm not agreeing to take jurisdiction over you. I'm allowing you to come forward so that you can make the appropriate record that you wish. Because my concern is, even if you project your voice, sometimes the microphones are just these little triangular things on the table. So my concern is they're not going to pick you up. So I would prefer that you come in and sit next to counsel's table. I don't exercise jurisdiction over you by doing that if you choose to come forward.
All right, so thank you.
All right. If you can come up and have a seat next to Mr. Hertel. Well, I'll give you, my desktop says 12:05. It looks like the wall clocks say 12:06. And it looks like they're synced up with each other, so go ahead.
No disrespect intended. Are we on the public record, sir?
We are.
And as redundant as it might be, just please continue to be honorable. Your Honor, I am Phil Levers, lawful representative of the estate in question. I want it on the record. Y'all don't have jurisdiction. I voluntarily appear in this court today on special appearance. I move the court to take judicial notice of the Michigan Constitution as ratified without subsequent amendments in the U.S. Constitution and your oath to them, Your Honor. What say you?
Well, as I said before, I acknowledge I took an oath to uphold the constitutions.
Thank you, sir. Moving forward, Article 3, Section 2, Clause 2 clearly states that when a state is a party to the case involving a citizen of that state, the Supreme Court has original jurisdiction, which makes these proceedings improper, violate the Constitution. It's the wrong venue. the request that I've supplied, which I have to amend because now there are extra things added. And Mr. Champion also and RJ at the defender's office refused to allow us evidence. So I'm still being denied due process. Your Honor, for the record, I am making a clear and unequivocal demand to represent myself in this matter. I am invoking my Sixth Amendment right as recognized by the United States Supreme Court of Ferretta versus California, 422 U.S. 806, 1975. And we have read up on the Wiggins. What? McClaskill, that's right. The McClaskill and Wiggins and implied change in law. I do not accept standby counsel, which affirms my right to proceed without counsel when the waiver is made knowingly and intelligently. I respectfully decline any court-appointed attorney. You all are friends. Y'all know each other. You most recently took this seat, sir. I made friends with a lot of my coworkers in the past. I'm not going to get a fair trial here. Due process is being denied on that as well. I understand the nature of the charges against me, the penalty, and the risk involved in self-representation. I am making this decision knowingly, intelligently, and voluntarily. I ask the court to conduct any required inquiry to establish that my waiver of counsel is valid and to allow me to proceed pro se. Your Honor, I am making a clear and unequivocal demand to proceed pro se under Ferretta. I am not asking for different counsel. I am waiving counsel entirely. They are impeding upon my due process. Jawkins didn't give me anything that I asked for. In fact, he got upset at me, cussed at me, told me to mind my own business, look over this. Jurisdiction is broken. Due process is broken. I'm not being treated fairly. That is my stance. If you want to indict me on a grand jury trial, please do so. Otherwise, this needs to be dismissed with prejudice or full exoneration, or pull the trigger. Let me go up there. I'll talk to them. It's been a pleasure meeting you.
Well, it's been a pleasure meeting you too. When you say go up and talk to them, who do you mean?
Supreme Court
Okay, all right.
on a federal indictment, which as a national, we're in different jurisdictions, sir.
So, I understand you want to represent yourself. I have a couple questions in that regard. So first of all, by representing yourself, do you believe that you can conform to the rules of the court, the published court rules?
With that, finding out other things. Most recently about my hometown, the past two judges have been removed by the tenure council. So Canon 1 through 5, indeed, it also expresses that you're the guardian. Prosecutor is the guardian. Lawyers are guardians of our liberties and the constitutional right. So when someone pro se makes a mistake, and even on pro se, the prosecutor is supposed to be there to uphold justice, not pervert it. And that's what this is about. So Canon 1 through 5, if I make a mistake, please correct me. If I file something wrong, the clerk has let me and my wife know, okay, well, this isn't how we do this. We can accept an amendment, you write it in, blah, blah, blah. Okay, so I will do the best I can. I am very different since dying, coma, botched surgeries. I'm a permanent head trauma case. My short-term memory is gone. So unless I build a consecutive day after day, that same time, every time, I'm not going to remember. And Einstein said, it is worthless to waste brain power on things that you can write down.
So as the independent party here, and just so you know, I don't know how, I'm guessing you've probably done some checking into me, but I don't know. Before I was the judge, I was the prosecutor. Before I was the prosecutor, I was a public defender. So I've played roles in all three parts here. So
I watched your videos while you were a judge. I watched the one of the two gentlemen that were arrested, and you released them. You dismissed their case. They were arrested over off of 13th or something over by a body shop, running meth. But the officers, same two officers that are involved in my case, tandem, like they do most of the times, which is why they were so close together on my case. They had to realize that they had to be closer together after you threw that case out. They broke the Constitution. I watched what you did, and I watched two other videos, which they fully got what they deserved. They broke the law unequivocally. But those two gentlemen, yes, had the Constitution not been broken, you would have been just fine with proceeding forward with not dismissing their case. But on the grounds that the first thing that the officers did, they broke the law, and then they broke the Constitution, which is exactly what's going on here. My wife and I have been involved in several auto accidents where the Cadillac Police Department refused to fill out a police report. There's not $1,000 worth of damages. The lady dragged her vehicle all the way down the whole side of our truck, from the bumper to the front quarter panel. The captain of the Cadillac Police Department and 5 others were there, and they wouldn't write a ticket. So these two officers and other officers state, well, we don't have to do anything on private property. Well, this whole thing was on private property. The officer also stated that he observed me driving. That's a lie. Falsus in unum, falsus in omnibus, false in one thing, false in all. And if you begin it by a lie, how can you be credited to be believed at all? So the officer stated that he had probable cause because he observed me driving. That's a lie. Jurisdiction, lies. You're an honorable man from what I've seen.
So where I was going with that is that, yes, I can provide you leniency, but I can't do it in such a way that it's detrimental to the other side.
Correct.
My side, I'm kind of like an umpire. I call balls and strikes, so to speak.
Correct.
So while, yes, I can give you leniency, I can't spoon feed you things as to what to say, what to file, that sort of thing. So I guess my next question is if I do allow you to represent yourself, would you be willing to have an attorney somewhat of counsel where they wouldn't necessarily be the attorney of record, but you would be able to talk to them about, how to properly file something, how to, if you have any legal questions, how to, interpretation of the court rules, that type of thing. Is that something that you would be open to? So you would be representing yourself. You would just be able to rely on them as a reference.
The problem with that, sir, with all due respect, my wife and I asked Jockins for the supposed 14-second video of not our truck. Whether those are the victims or not, that wasn't my truck. In that 14-second video, that wasn't my truck. Now, I do not accept the fact that I had to watch it at the defender's office, and I still have been refused because policy and procedure, because others have put this stuff out on public notice. My wife has had her video of her accident because she had to take up the reins and take care of herself through her job. Nobody knows about that video. Nobody's seen that video. And most recently, we found out a bunch of other things. There's a conflict of interest. And the prosecution didn't say anything. My wife, who was ran over and her legs are destroyed, was made a victim. She's being made a victim again.
That's in
because
this case?
Yes, sir.
All right.
She was removed as victim and placed as a witness.
So let
That's
me,
mis-
so let me ask you, and I understand why we're getting a little heated, but
Sorry.
hold on, let me get my question out. So when you say you haven't been provided discovery, do you mean that it hasn't been physically handed to you, but you've had the opportunity to at least watch it?
Discovery, as I'm learning, is a multiplicity of things. And they have specific names.
So let me be more frank, because again, I'm on a time clock here.
Correct.
So
Counting.
let me just ask you, have you seen the video? Not has it been provided to you, but have you seen at least what they're saying is the video?
No.
Okay. Have you seen the
Because
police
the
report?
Defender's office, while playing it, it stopped. There's an error. And the video was never allowed to be loaded back up and seen past a specific point, and it crashes every single time.
But they at least,
RJ stated, he's like, I just watched all of these. I don't understand what's going
but
on.
they at least attempted to play it for you and then it crashed,
I wasn't.
presumably.
Discovery means that the evidence goes to me.
No, I understand, but just focus on my question for a minute.
In this courtroom moment, we see a tense legal exchange between the judge and the defendant during a probable cause conference. The defendant strongly argues that his constitutional rights have been violated. He claims the court does not have proper jurisdiction, questions the legal process, and repeatedly says he is being denied due process. One of the biggest points in this hearing is his request to represent himself. He clearly tells the court that he wants to proceed without a court-appointed attorney and invokes his right to self-representation. This creates an important legal issue because courts must make sure a person understands the risks before allowing them to act as their own lawyer. The judge remains calm and tries to explain the procedure. He makes it clear that the defendant can represent himself, but he must still follow the same court rules, deadlines, and legal standards as an attorney. Another major issue discussed is discovery. The defendant says he has not received full access to the evidence, including video material and reports. The judge explains that once he is representing himself, he can file a formal discovery demand, and the prosecutor will have a set amount of time to respond. This hearing shows the conflict between personal constitutional arguments and the structured rules of the court system. The defendant believes the case should be dismissed, while the judge explains that those arguments must be raised at the proper stage. Overall, this is a powerful courtroom moment showing frustration, legal confusion, and the importance of procedure in criminal cases.